we are referring to the Tata Sons boardroom battle. Couple of things have emerged from it. One, that probably non-public information was being shared by listed Tata companies to non-directors, something which I think the SEBI insider trading rules forbid. Another set is that we hear that the Tata Sons group might move to change the directorship, especially in places where Cyrus Mistry holds the chair. For both these issues, let's invite the lawyer, Sandeep Parekh of Finsec Law Advisors joins us. Good morning, Sandeep. Thank you very much for joining us. There are several quotes that we can pick up now from the public space itself. This is not any great investigative journalism. Let me just refer to some of the statements that came from Cyrus Mistry's office. First on Tata Docomo. Mistry has always mentioned that Tata should honor all commitments within the law. This stands as based on Tata Sons board view and was always consistent with a series of board meetings in which Docomo issue was discussed. Okay, maybe it was discussed on principle. Let's look at the Tata Power well-spun quote. The quote says, in the early part of this year, Tata Power made a presentation to Tata Sons that a significant focus area would be renewable sector. The Tata Sons board appreciated it. On 31st May, a note was circulated to the board of Tata Sons and to Ratan Tata, providing information about the well-spun transaction and asking them if they needed further information. Now, everybody in the Tata Sons board is not a director in Tata Power. Is this tenable under SEBI law?
So Lata, thanks for having me. I think the insider trading norms are very, very clear in terms of it has to be, the information has to be shared only with the management and directors, and only people, even it's not only restricted to directors and management, but only those people who need to know that information. So I think it's a very clear exposition of SEBI that no information should be shared with outsiders, with people who are not connected with, even within the company, with management and direction in that particular, in that specific issue. For instance, acquisition of a company, you don't need to involve the HR head or other random other people into the conversation.
Okay, Sandeep, does this apply also to non-listed companies? For instance, again, Cyrus Mistry on the Tata Sons independent directors issue. Let me quote him again. As an example, once the trust directors Nitin Noria and Vijay Singh had to leave a Tata Sons board meeting in progress for almost an hour, keeping the rest of the board waiting in order to obtain instructions from Mr. Tata. Obviously, Mr. Tata is not a director of the board. Will this also, or can this also come under SEBI lens?
So, see, specifically, this is a slightly difficult question because Companies Act indeed does provide for a prohibition on, against insider trading. The problem is it's never been applied in an unlisted concept really, because insider trading comes in, the origin of insider trading itself is a breach of fiduciary duty and public interest involved in such cases. So where you only have 2 or 3 or 4 shareholders, as in this case, the applicability itself has never been tested before. But having said that, I think what is disturbing is the corporate governance norms, which are again reasonably clear, which say that information should not be shared the information should not be shared with outsiders.
How might this?
I think those norms definitely.
Sorry.
No, go ahead.
Yeah,
so I think the corporate governance norms are certainly breached.
Okay, so how will this likely play out? Would it be something which a private investor, a minority investor, writes to SEBI? Will it be one of the proxy investors who might take this up? Or will SEBI or MCA take suo motu cognizance of these statements which are now in the public domain and investigate? How might this pan out?
No, so I think you named each one of the ways in which SEBI could initiate action. So they can take suo motu action, they can take action based on, let's say, proxy advisor or a real investor of any of these companies. So based on that, SEBI can initiate investigation and ultimately hold the people who tip that information and the tippee of that information to be in breach of SEBI regulations. And in fact, we recently, a few months back, we saw a SEBI action where SEBI has hauled up people even within the company, within the management of the company, who did not need to know from kind of accessing information. So I think SEBI is very clear that they don't want information floating around. Just even if there's no trading, just the mere access of information from outsiders or irrelevant people within the company itself is prohibited. So I think that position is very clearly brought out by SEBI.
Oh, that's important. Was that the Piramal case you're referring to? You don't have to trade, but even if you know or you were told, it can be breach of law.
Yes, yes.
Okay. Sandeep, morning. You know, our sources...
And in fact, the law is also quite clear if you...
Yeah, please go ahead.
No, so the law is also very clear. The 2013 insider trading regulations, which are the new regulations, make it amply clear that there is no trade needs to happen. So the law is itself very, very clear.
So, you know, our sources are indicating that the independent directors, at least some of the independent directors, have opposed the removal of Cyrus Mistry. How do you think the Tata Group will, how do you think things may play out from here?
See, this is going to be more of a strategic issue rather than a legal issue. But let me walk you through the kind of logistical issues involved. So Tata's, I assume, have between 15 and 30% of, except with one or two exceptions, they have between 15 and 30% of most of the listed companies. Which means they have limited votes. And again, Tata Sons and Tata Sons group combined, cross-holding combined, again, it ends up being a very different number. So whether they will vote cohesively to oust Mr. Mistry itself is the first question. Secondly, the concept of chairman is, you know, something which can be inducted by a board or expelled by a board. So it's a board issue. But removal of the director himself, in this case, would require shareholder approval, and you know there are arguments that it may even invite the related party concept, which would mean that Tatas may be forced to not vote in those meetings. So I mean that's an open question which is open to debate. But those are the kind of issues which will crop up. Number one, shareholding. Number two, the strength in the board. Because these are, you know, very often held, large stakes are held by public institutions, large stakes are held by mutual funds, large stakes are held by other people who may or may not want such a sudden change.
Okay.
So I think it's if Mr. Mistry wants to fight it out, I think it's going to be a long battle ahead.
No, actually, see, Tata Sons could argue, or Tata Group could argue, that I have 30% in Tata Steel. All those numbers are running by as you speak, Sandeep. I have 30% stake in Tata Steel. My nominee directors are Cyrus Mistry, X and Y. And I want Cyrus Mistry removed. He's my nominee in the board and I want him removed. That argument doesn't wash? It can't be done?
No, I'm not saying it can't be done. I'm saying that is the 30% number one? See, first of all, it has to go through a process under Section 169.
Which is?
He has to be given a notice. Shareholder notice has to give out all basically a show cause notice is contained in the shareholder notice.
Okay.
And he's allowed to address the shareholders and tell them that why he should not be removed. And finally, the number of votes in favor of removal should exceed the number of votes which want to retain him. So I mean, this is going to be simple mathematics at the end of the process.
Okay.
But yes, with 30% stake, I would assume that it would be successful.
Okay, but an EGM has to be called.
Certainly, EGM, not, as I said, not just an EGM has to be called, but it becomes kind of a court hearing. So
okay.
The notice for the EGM itself has to specify why the director should be removed, and that director is entitled to present his case as if in a court of law,
okay.
To say why he should not be removed, and you know that whole proceeding itself is bogus.
Okay.
So I mean he's entitled to fight it.
And we have breaking news on CNBC.
And, plus the process.
Okay. We have breaking news on scene, Sandeep, that 3 independent directors of Tata Motors have actually said that they back Cyrus Mistry, that he did a very good job. One of them declined to comment, but 3 of them have actually backed him. Now, aside from the majority factor, is there also a corporate governance issue here? I mean, in the past, if one independent director put in his resignation saying that this is against his conscience, this can become a stink, isn't it? So aside from the numbers, is there an intangible risk that the group might run if it forces the issue?
Yeah, so I mean, see, having lived in Bombay during this Diwali, this was a stink, but I think we're looking at much more than a stink. We're looking at Delhi kind of pollution here. I think we're looking at toxic issues. So if it becomes a battle wherein, say, independent directors take a particular view and other directors who are interested, who are executive directors take a different view, share some shareholding votes for, some against. Obviously, this is going to be a very major distraction from doing business, first of all. And secondly, it will be very unpleasant. There might be court battles there. So essentially, I think it's going to be a toxic environment, no matter which way you see it.
Okay, Sandeep, we've run out of time, but thank you for joining us and explaining this entire issue and what the way forward could be. With that, it's a wrap.